are on the record and live streaming, and this is Holder versus Hacker King Sherry Agency et al. Docket number 17-768CK, and this is the time set for hearing on the defendant's motion, defendant Hacker King Sherry's motion to compel an answer to interrogatory number 5 of the defendant of the defendant's 8th set of interrogatories. And could I just have your appearances, please, for the record?
Sure. Frank Fleischman for defendant Hacker King Sherry.
Kevin Comer on behalf of Todd Holder.
Okay, Mr. Nave, we can't hear you.
Is this helping me?
Okay, we can hear sound, but it's pretty awful sound. I mean, it's not.
Participating in this, I'm just here to observe. It's not my motion and I'm not involved.
I got it. I suspected that, but I just wanted to, just for the record, Mr. Nave is present. He represents Pioneer, but he is not participating. This isn't his motion, and he's not participating. And we can't understand him anyway. So, Mr. Fleischman, your
Well, at least you
motion.
didn't say that about me, Judge.
Go ahead, Mr. Fleischman.
Your Honor, we submitted interrogatories to plaintiff, and the 5th of our 8th set was who was the insurer, or tell us about the settlement of the underlying claim. And the plaintiff objected to the interrogatory on the grounds that it seeks information not relevant to this litigation. MCL 53101 excludes tort damages from someone who's driving a vehicle that is uninsured, and if they're the owner of the uninsured vehicle. That is what plaintiff is claiming in the case against Hacker Sherry and Pioneer Mutual. I think that it's totally relevant to determine what the ground of the settlement with the third-party actor was.
Okay, thank you. Mr. Comer?
Thank you, Your Honor. So as part of this claim, well, just by way of history, this case is a little bit complicated. Initially, what ended up happening was it was Pioneer who brought suit against Mr. Holder to rescind the actual policy. Plaintiff countersued for no-fault benefits. There was a motion for summary disposition, and I think that was in May of 2018, over 2 years ago now. And it was right about that time when the Bozzi decision dropped like a bomb from the Supreme Court. And at that point, the parties all said, let's let the dust settle. And there's never been a ruling from the court, nor has there been any finding that Mr. Holder was uninsured. So that's what all this litigation is with regard to Pioneers. We want no fault benefits. They want to rescind the policy. And then we brought in the insurance agent to say, well, if in fact, if it's ever found to be through this litigation and Mr. Holder is uninsured, then you, insurance agent, are going to be on the hook for these no fault benefits that we're seeking from Pioneer. We are not seeking any underinsured motorist benefits from Pioneer. We're not seeking any tort damages for pain and suffering under MCL 531.35 from Pioneer. The only thing that we are seeking from Pioneer are the benefits that are allowable under the No Fault Act, which would include allowable expenses for medical bills and the potential wage loss. And I think there's some household services as well, but that's not a major portion of the claim. So we're not seeking any pain and suffering third-party damages from Pioneer. We have resolved that claim already with the tort fees. And because we're not seeking any of those benefits from Pioneer, we don't think that it's relevant because I'm not claiming those in this case. I've even stipulated to that fact. When an order was entered prior to the motion that we're not seeking any pain and suffering damages at all from Pioneer, nor are we seeking those pain and suffering damages from Hacker King Sherry. And the further complicating factor is, Judge, we entered into a settlement agreement with the underlying tortfeasor and the carrier for the tortfeasor. This was from June of 2018, and we are subject to a confidentiality agreement. As part of that settlement agreement is I can't release the terms, nor can I even release who the parties are according to the settlement agreement. So number one, I'm not seeking those damages. I think it's irrelevant because it's for pain and suffering. It doesn't have anything to do with medical expenses or wages. Those are two completely separate and distinct claims. And the other reason is because I'm subject to a confidentiality agreement.
Okay, thank you. Mr. Fleischman, any last words?
The confidentiality agreement, Your Honor, states, as I understand it, that it should not be breached unless it's ordered by the court. And this court has the authority to breach that confidentiality agreement.
All right.
Thank you.
Thank you. Well, as we all know, the statute says that an uninsured driver can't seek tort damages against the at-fault driver, or against the other driver. So that's the basis of this motion, and the logic or the argument is that if the plaintiff brought and settled a third-party claim against the at-fault driver, then plaintiff would have to be insured under the statute, otherwise they couldn't seek tort damages. And if the plaintiff was insured, he has no claim against the defendant, Hacker King Sherry. But the plaintiff isn't seeking tort damages against Hacker Sherry King. There's never been, has not yet been, any adjudication as to whether plaintiff was uninsured. So the statute just doesn't apply to this case. And even if there had been some adjudication or plaintiff was shown to be uninsured, the plaintiff can settle with anyone the plaintiff wants to settle with for anything that he wants to. And that's particularly true here where it was done pre-suit. So I don't think that the confidentiality provision is really an impediment. I think the court could certainly order it if it were relevant, but it's not relevant to anything in this case. So for those reasons, and because discovery, of course, is only allowed for matters that are relevant, and there's nothing about interrogatory number 5 that has any relevance to this case, I am denying the defendant's motion to compel an answer to interrogatory number 5. And
thank you, Your Honor.
Do you want to do an order, Mr. Komar?
I will prepare the order, Your Honor.
Okay.
Thank you, Your Honor.
You're all set. Thank you.
Thank you.
Thank you.